There are two types of powers of attorney. One that deals with property and financial affairs, and one that deals with health and welfare. And we generally recommend that clients do both, because inevitably when decisions need to be made, they might need to be financial decisions or they might need to be health or welfare type decisions. What you need to think about when writing a power of attorney is, who am I going to appoint as the attorney, as the person who will look after my affairs if I'm unable to. Essentially, it needs to be someone you trust. They need to be over the age of 18 and preferably geographically local to you, because at a practical level they might need to step in at short notice. You should consider writing an LPA pretty much any time you think about writing a will. We always associate lasting powers of attorney with elderly people, because naturally as we all get older we get more incapacitated, more infirm, more vulnerable, and therefore we might need help. But the reality is we can all walk out the door, get knocked down by the number 10 bus, bump our heads, not quite be the same again, and need a power of attorney. So actually, if you're writing a will, thinking about dying, thinking about not quite dying, and make a power of attorney at the same time. If a power of attorney is in place, we generally advise that it's registered straight away. A power of attorney needs to be registered with the court before it can be used. Then it becomes a judgment call, normally from the attorneys, as to when the person who's given them authority has actually lost capacity. If the donor, if the person granting the authority thinks they are beginning to lose capacity, they might say to their attorneys, I need some help. But generally, it's the other way around, and the attorneys step in when they feel that the time has come that someone needs to step in and help. If there's any doubt, go to a doctor, get a capacity report.